Welcome to the Real Estate Raw Show, hosted by Joe Mendoza.
Hi, guys. I'm super excited to have one of my favorite attorneys, a longtime friend who I've known forever on the show today, Miss Kim Lisa Taylor. She's super, super amazing. Wrote this incredible book I have right here. We're going to be talking a lot about different things on the book and the top 5 mistakes real estate investors make when raising capital. Kim Lisa Taylor, welcome to the show. How are you?
Hey, Joe. I'm happy to be here. Thanks for inviting me.
Yeah, super, super excited to see you again. It's been forever. So let's do a little backstory before, just to get the audience familiar with who you are. Tell us a little bit about yourself, and then we'll jump right in.
So I am a corporate securities attorney. I've been doing real estate securities offerings exclusively since 2008. Have done them. I own my own law firm called Syndication Attorneys. You can find us at syndicationattorneys.com if you want to read in depth about our background. But I actually started out with a prior career before becoming an attorney. I was a professional geologist. I'm still licensed as a professional geologist in California. I maintain that. Yeah, hey, you never know when you need a fallback, right? Hopefully you don't. But I like to say that's what keeps me
awesome.
grounded, right? That's what keeps me grounded as an attorney.
There you go.
Yeah, my little geology joke. There's more, but I won't. But I went to law school as a second career. I had been practicing as a geologist and environmental consultant for a number of years and looked into my future and said, maybe there's something else I'd rather be doing. So I decided to go to law school. I went at night while I continued to work full time. So took the night program's a 4-year program. I did that in Colorado. And when I was in law school, I thought, I didn't even know what I wanted to use my law degree for. I thought I wanted to use it to further my own business. But then I practiced, I thought I'm going to start a business and I just want to have this law degree because I think it will help me with my business. That was my thinking at the time. But I ended up getting out of law school. I practiced environmental law for a while, which was kind of a shoe-in from my past career. And I could have stayed in that field, but I learned that almost all the environmental cases were litigation. They lasted for years and years and years. And I actually talked to this one elderly attorney who said to me, "Oh yeah, I have one environmental case I've been working on for over 15 years." And I just thought, "Oh God, shoot me! I don't want to do that." So I was working as a contract attorney for other people. So I would, go work with these solo practitioners and give them a hand so I could try out all these different areas of law. And I met somebody who was doing securities offerings. And I thought, oh, this is it. I really enjoy this a lot. My husband was a real estate investor. We were getting into real estate investing ourselves. And the way that I actually met him is because we went to a multifamily training event to learn how to buy multifamily properties. That was Dave Lindahl's RE Mentor group. We joined their coaching program and went to their multifamily millions boot camp, learned all about how to buy the real estate and what not to buy and all that stuff. Then joined the coaching program and went back to Boston to their private money boot camp. And it was the first one they'd ever done. That was like in 2007, I think. And while we were there, I met the attorney that was teaching that class and said, "Well, I do work for other attorneys. I'd like to work with you." Turns out he was in California, just about 75 miles from where I lived. So we started working together. We formed a law firm together, did really well for a while. And then my husband and I decided we wanted to move to Florida. And so we packed up, left. I went and got licensed out there and started Syndication Attorneys.
That's awesome. Great, great story. There's some things I didn't even know about you. Thanks so much for sharing. So in this journey, being a syndication attorney, and also with your prior background with your husband about being real estate investors, I'm sure you're seeing some red flags. I'm sure you're seeing some like grand slams, like, oh my God, I should have jumped on that one. But today's focus is about the top 5 mistakes real estate investors make when raising capital, me being an investor myself, me being in the real estate industry over 20 plus years, I'm seeing some of these, and unfortunately, some people I know went to jail under what they call a supposed Ponzi scheme. And I'm like, man, why, I'm seeing mistakes out there. And, they get excited about these random boot camps, just to name a few out there. I don't want to throw anybody under the bus or whatever, but they come out of the boot camps and then all of a sudden they start charging hard without the proper coach, the proper mentor, the proper attorney or professional helping you out. I think the first one, let's get into that. What's the first common mistake?
Well, people don't follow securities laws. And, so I have a saying about that. The people that don't follow securities laws are either people that don't know, don't care, they're in denial, or they're in jail. So you don't want to be any of those people. If you don't know, you need to understand that when you're raising money from private investors, that you have to follow securities laws. So you need to learn what that means. All right. And what that basically means is if you're selling interest in your company or you're repeatedly borrowing money from people and your business depends on that. And we're talking about, your family, friends, neighbors, acquaintances, people you meet at local real estate investment associations. We're not talking about banks or hard money lenders. Okay. We're talking about ordinary people with some savings or self-directed IRAs that maybe have other careers and other jobs. They're just looking for some side investing opportunities, and they're not in the business of loaning money or investing, as an investment banker or something like that. So when raising the money from private investors, if you're having them invest in your company as a passive investor, so they're not making day-to-day managerial decisions, they're not in charge of generating their own profit, they're relying on you to generate the profit for them. In that case, then you are selling securities in the form of investment contracts. So investment contracts are one way. The other way is promissory notes. And that all comes from the definition of what's a security in the Securities Act of 1933, which is still alive and well and still enforced every day. It has been updated since 1933, but that is still the act that controls securities offerings in the United States. And so within that act, there's a definition of what are securities. And the very first thing on that list are notes. So promissory notes, and then later down in the list are investment contracts. So those are the two things that real estate investors have to understand, that when you're selling either of those things, that you are selling securities, and then that now means that you have to follow securities laws. And so that means you either have to register your offering, which is meaning getting pre-approval from regulators before you even offer it to anybody, which is nobody does that for real estate because it's long, it's expensive. That's the IPO process, the initial public offering. That's taking your company public. You're not going to do that for, buy a multifamily property or some single family properties in your community. So you either have to register it or you have to qualify for an exemption from registration. So everybody uses the exemptions. The most popular exemption is Regulation D Rule 506. There's a set of rules that go along with each of the exemptions that you could possibly follow. There's state exemptions that you could follow if you're raising all the money in one state. Then if the property and all of your investors are contained within one state, then you could look at your state securities laws and see what kind of exemption might apply to what you're doing. But if you're starting to cross state lines, you're buying properties in other states, or your investors are coming from multiple states, then you're going to look to the federal offering, so that you just have to follow one set of rules and it supersedes all the individual state laws that would otherwise apply. So the federal rules, this Regulation D Rule 506, there's two options under 506. There's Rule 506B and there's Rule 506C. Rule 506B allows you to raise money from friends, family, and acquaintances, people that you know, people that you've already established relationships with, people that know you. You have to be able to prove that you had a pre-existing substantive relationship with those people, and you can't find them through any means of general advertising or solicitation. but you can raise an unlimited amount of money from an unlimited number of accredited investors and up to 35 non-accredited but sophisticated investors. So, most of our clients have sophisticated investors in their world that they've met that would be fine investors. They're not accredited. They don't have $1 million net worth or $300,000 a year income if they're a married couple. So they're not accredited, but they have some level of education, experience, knowledge that would make them capable of understanding the merits and risks of that investment. So more than someone with just some savings and a job that's never invested in real estate before. So that's the Reg D Rule 506B. That is by far the most common exemption used, not just by our clients, but also according to the SEC. There's about 25,000 Reg D Rule 506 offerings that are Form D is what we file with the SEC to notify them that we're claiming that exemption. There's about 25,000 of those filed every year, and the bulk of those are Reg D Rule 506B offerings, median raise being about $1.5 million with about 14 investors. That's according to SEC statistics. The other option is Reg D Rule 506C. This is the option that really only applies to people that have experience with raising money from private investors on other syndicated deals in the past. So then they would be able to go out and start advertising for investors, but the only people that can invest have to be verified accredited investors. That's only about 10% of the population. So realize if you go that route, you've cut out about 90% of your possible investors. So you have to be, have kind of run through your family and friends, already have them invested with you before you, and getting that track record before you want to make that leap and start advertising for investors. So that's the first thing is people, first of all, don't understand securities laws. So now everybody on this call, you're no longer in the don't know category. Right? You're not following securities laws. You're either
that was a lot of information, Kim. So make sure, guys, you follow those securities laws. I mean, that was jam-packed with information just on number one. Okay, number two. What's the number two mistake?
Well, so I think there's a couple that we should still cover under the not following securities laws. So the main ones under Reg D Rule 506B that I see people making is they don't establish that relationship before they start making offers.
Okay.
Right. So people are email blasting to everybody they've ever met. I mean, I get email blasts all the time from people that have never had a conversation with me about my finances. They have no idea whether I'm accredited or not accredited. Obviously, I would qualify as sophisticated under any standard, but they've never asked me those questions. So until they have that information about me and they know whether what they're offering me is suitable, an investment for me, they have no right to send me those Rule 506B exempt offerings that include non-accredited investors. Finder's fees. Here's another one. So there's a whole lot of people that are trying to solicit other people to raise money for them. And they're offering them some kind of a commission or what's called transaction-based compensation. So it's any compensation based on the amount of money that person has raised is illegal unless the person raising the money has a securities license that allows them to do that. And there are very few securities licenses that allow that. They're hard to get. It's not something that any ordinary person can do. California actually has a rule. California is one of the only states that has a finder's fee rule that allows you to register as a finder in California. There's a nominal fee for doing it. There's an application process, but then you can actually earn commissions as long as the deal's in California, you're in California, and the investor's in California. So that's something that, somebody in California might want to know. By the way, I am licensed in California and Florida. But we help clients all over the country because securities laws that our clients are following are under the federal laws. And so we're able to help them in any state with that. But back to your question. So, advertising without a relationship is probably one of the number one mistakes I see people make. They don't create the right substantive relationship that pre-exists the offer. They try to either make the relationship after they've already made the offer or they don't ever try to get that information at all that's necessary. Anybody wants to know what that means, there's an article on our website at syndicationattorneys.com in the library. It's the first article that will pop up, called How to Create a Substantive Relationship. It tells you exactly what the SEC says you need to know about someone before you can offer them an investment opportunity. And it even has an example list of questions attached.
Nice. Very, very valuable information. Top mistake number 2.
Okay. Drafting their own documents. So somebody will, go out on the internet, or they have a buddy who just did a syndicate. So one question we haven't answered is, what's a syndicate? It's just a group formed for a common purpose. So anytime you're putting a group, you have 2 or 3 people that are putting a deal together, and they're going to do all the active work, and then you're going to bring in some private investors to put up the money. So you've created this group for a common purpose, which is to buy the real estate. That's called a real estate syndicate. So you go out, you got a buddy that did a syndicate before, and he's going to loan you his documents, and you're going to try to, tailor those to your deal. It's just a big mistake to do that. We have had to fix other people's deals multiple times. Sometimes they are fixable. Sometimes they just have to live with their mistakes. You can create adverse tax situations for yourself and for your investors just by structuring your deal incorrectly. You can create legal issues by not having the correct corporate structure within your syndicate, which is not just one LLC, it's usually multiple LLCs. Each of them have a different purpose. You can create the wrong kind of structure where everybody is going to be taxed at ordinary income rates. Just by trying to create, picking the wrong box when you're forming an LLC. If you don't say, say it's going to be member managed and you got 20 people in it, well, how are you going to do that? Everybody is a managing member and they all have a say in how you run it. Okay. And are there really enough jobs for people, or are you just calling it that and then you're doing all the work? Or are you creating a manager managed LLC? And, just creating the filing, sticking the wrong box on there can have all the difference in just how your LLCs are formed. And then making sure that you have the right operating agreement that reflects what you've filed and reflects what actually is happening in reality. So, drafting your own docs is one thing. So that's, just fraught with pitfalls. The other thing is actually not following the documents that you have. And so that's where people get in trouble a lot too, is they don't understand the documents. They didn't have somebody explain it to them. They didn't work through what they actually wanted to happen. In one case, I actually had a client who someone else had gone to a seminar and they got some docs somewhere and they thought they were smart enough. They drafted their own documents. And then the other partner wanted to kick them out of their deal. And because of the documents that they had drafted, we were able to do that.
Ouch.
Yeah. Yeah.
That one hurt. Wow. Yeah. I was, I think I shared with you the other day that I was at a meetup and somebody approached me and he said, "Hey, what do you think of this offer I found online? I'm about to present it." And I'm like, "Are you kidding me? You're going to use that?" I mean, he was just going to take something he found online and use it to purchase some property without any attorney or agent representation. Like, man, if this is going to be your first, this might be your last.
Yeah, well, and that is true. I will say that when my husband and I bought our first property, we didn't use a real estate attorney to draft the purchase agreement for us. It was a multifamily, and it ended up probably costing us several $100,000.
Wow.
And I'm an attorney. I thought, oh, I'm smart enough, I can do this. And no, you can't. You have to have someone that understands and deals with that area of the law all the time, who can help guide you correctly in that transaction. And because had I had in our case, We could have put a clause in there that said that if the seller did something to cause vacancies or, effective vacancies, that they could have been held responsible for it. And they actually did that. It was the government agency that we were buying the property from, and they enticed our tenants to leave by offering them money. Wow. And so out of 27 units, we ended up with 16 vacants. And it took us a long time. We had, a lot of extra money to turn all those units, and then a long time to get them filled. And so that was a struggle. So, just understanding that there's little nuances in these deals that you don't understand, and you really need somebody with the right experience to help you with that. We don't do the real estate purchase agreements because we're not real estate transactional attorneys. We're real estate securities attorneys. So everything we do relates to people who are raising money from private investors.
Got it. Top mistake number 3.
Don't hire the right attorney. I think we just kind of covered that, making sure that you have the right attorney that has the right experience. So, your buddy that just got out of law school, probably not the right person to help you draft a securities offering, probably not the right person to do your commercial purchase agreement, or your buddy that's a trust and estates attorney isn't necessarily the right person to be helping you draft complex real estate transactional documents.
Absolutely. All right. Top mistake number 4.
Waiting too long to hire your counsel, right? So, or not hiring anybody at all, but waiting too long, because for us, it takes us a period of time to be able to draft the offering documents. So typical scenario is a client will come to us, they have a multifamily property under contract. They usually are going to have, in order to syndicate and raise money, you really need 90 days. Right. So you really need to have at least a 90-day escrow period. If you can't have a full 90 days, you need a 60-day escrow period with a 30-day extension already built into your contract. So that's, a little tip for your purchase agreements. So you need 90 days. And that's so that you have time to conduct the due diligence. We have time to draft the offering documents. Ideally, we should be drafting your documents while you're conducting your due diligence. And then if that both completes at the same time, then you have the rest of the period of time. So that's going to be 45 to 60 days to go out and raise the money and to process the bank loan. That's your ideal situation. We don't want people to hire us before you've done a certain amount of due diligence. So we always say you really need to have a signed purchase agreement, because until then you don't have a binding deal. Doesn't matter what your LOI says. You don't have a binding deal till you've got a signed purchase agreement. You've physically been to the site, or someone from your team has physically been to the site. You've driven through the neighborhood. You've made sure that, this looks like a winner. We want to buy it. And then the third thing is you have to review the financials from the past person. If you're buying a single family property, you don't have to review the financials, but you do want to know what's going on as far as rental comps and sales comps in your neighborhood, right? So you've got to have done that kind of research. For a multifamily property, you want to see their history, because that's going to be important to you as you figure out what your plan for that property is and how you can improve it. And that's also going to be important for your lender, because they're going to be looking at that history to determine if this is a risk they want to take. And you're going to present all of that information to your investors. So that's part of like the drafting your own docs, is making sure that you're providing the right disclosures to your investors, that they understand the risks of the investment, how it's going to be structured, who's involved in it, what's your past experience, and what are your 5-year projections for the property, what's your proposed exit strategy, what's the money that you need in order to get into the deal.
If somebody was under the gun, they procrastinated, you were one of the last calls, what would be like the quickest turnaround time you've ever done? Or like, God, if I'm under the gun, I need a week or 2 because of the state too. Like, what's the like absolute?
So for new clients, it's always going to take a little longer. Our more experienced clients that have done this before, have seen our documents before, have been through our processes before, we can get things done within a couple of weeks for them. For a new client to come to us and say, we want everything done in a couple of weeks, everybody has to be Johnny on the spot. So we do have rush fees for that. If somebody wanted to, pay us extra, so we work nights and weekends on their project, that is something we can do to get it out as quickly as humanly possible. But then it's on the client, right? Because they have to review the 140 pages of legal documents that we just created, make sure that they're 100% correct. And then they also have to prepare their own property package to accompany the documents that we're creating. And all of that has to be finalized. Everybody agrees on the content. And then once that's finalized, they can go out and start raising the money. So I would say 2 weeks is, probably the absolute minimum that you could really get something done, but that's going to be very uncomfortable for you and for us. And it's going to cost you more.
Got it. Thank you. And number 5, top mistake real estate investors make when raising capital.
So, they don't establish relationships with investors before they have a deal. So I've heard this, countless times, it's find the deals, the investors will come. Well, I've actually seen a situation where somebody believed that and ended up losing $75,000 because they had 2 properties under contract and they didn't know a single person to call. And so then what happens is you get desperate and you start relying on other people. So they met somebody who said, oh, I can raise all the money for you. And then that person didn't ever come through. They never did it. I've had other people that, have relied on, big, what I call them whale investors, right? You keep chasing after this one investor that's going to do my whole deal. Well, there's a lot of reasons you don't want to do that. Number one is that you just bought yourself a new boss. Okay. You work for them, right? They control the deal because it's all their money. And if they want to get rid of you, they don't really need you once they have the deal. So they'll find a way. They have the money. They have the money to litigate it if they have to. So, you're just going to get squeezed out, or they'll change the terms right before closing saying, well, I would do the deal, but I've been looking at it and I really think that now we need to do it as a 90-10 split. And, all of a sudden it doesn't make it worth it for you to do the deal. Or the most common thing that happens is they'll string you along because they're too polite to say no. And they'll keep adding conditions. Well, I would do it if that, I would do it if this. And then all of a sudden something will happen. Oh, sorry, I just had another investment blow up and I've got to put all my money over there. Okay. Or they just stop answering the phone. Right. So they go dark on you, or they just, something happens, they can't do it anymore, so the whole thing ends up never happening. And I've seen that happen probably 95% of the time when someone comes to me and says they have a single investor that will do the deal. Unless they've done past deals with those people before, it's very unlikely, especially if you're new. Now, if you're very experienced and you come, you've done 5 or 10 deals and you say, I've got this one investment banker that's putting up all the money, well, they probably are going to come through because you have the track record to sustain that. But somebody who doesn't have that track record, don't waste your time on those whale investors, because, it just leaves a wake of destruction in its path. And you're the one that's usually got a lot of money out that you don't get back. I saw some people that were, last year, they were all the way to the closing table on on a big raise, like $1.5 million, a $2 million raise. And they were waiting for one investor to come through with $400,000 that never came through. So they were all waiting at the closing table. And it's just, I can't tell you how much money they probably lost on that deal, but it was a lot. And they lost credibility with those investors. They lost credibility with the broker, with the lender. There's just a lot of broken relationships left in the wake of that.
Wow. Yeah, no, I had a very similar experience with a coaching client that I was working with. Before I started working with him, he said he was already under contract on a land development deal on like a 80 unit lot parcel. And he was like, hey, Joe, do you know anybody with money? I'm like, what for? Well, my money just went hard, which was 150,000. So it was gone. And now he's fundraising, scrambling, because he had zero capital raised. I was like, oh my God, that was a tough lesson to learn.
Yeah. Yeah, it's hard, and you can't afford to lose many deals like that. Most people can't afford to lose many deals
Yeah.
like that.
I mean, you said it spot on. Like then you're going to burn relationships because they lost their trust or even confidence in you, which is powerful. This was powerful. Well, I think we have a couple minutes. I sure do. If you have a couple minutes,
Yeah,
maybe we
sure.
could dig a little bit. So
Yes.
you've got tons and tons of resources on your website. You wrote a book. Somebody just went to a boot camp. They have some kind of understanding. They have a bunch of rich friends, rich uncles, whatever. They're like, okay, man, I'm going to do this. Would you recommend JV? Would you recommend syndication? Would you recommend, what would you recommend?
So JVs, we recommend JVs. Okay, so the difference between a JV and syndication, let's get that straight first, is that in a joint venture, all of the members are actively involved in generating their own profits. That's the SEC definition. Okay, so in order to have a joint venture, all of the members have to be actively involved in generating their own profits, and it has to be more than just a voting right. So you're not going to take control of their money. They're going to put in the money when you need it. Everybody is a managing member in this member managed LLC. That's the structure we use for joint ventures. And they all have the right to bind the company contractually or to open and close bank accounts. They all have to agree before you can make a decision. So that's a joint venture. So you don't want to do that with more than 5 people. I've done this many, many, many times. And anytime we've had people in a joint venture with more than 5 people, it has not gone well. It's a lot of times it hasn't even gotten to the closing table before they're fighting, or somebody's dropped out, or something has happened to where it just doesn't work out the way that they had hoped, and it's a nightmare for them. So 5 people or less in a joint venture. Now, you could use a joint venture as the manager of your syndicate, right? So when we do create a syndicate, we usually create a manager managed LLC that sells interest to investors and takes title to the property. That manager itself is its own LLC comprised of the people that are going to be actively involved in generating the profits for the passive investors in this other LLC. So that management LLC could be a joint venture. And so that, even in that scenario, you don't want to have more than 5 people. When you have passive investors, you're going to create this manager managed LLC. The manager is going to do all the work, and the members are just going to sit back and wait for you to generate profits on their behalf and to execute your business model. So that's, the distinction is, when would you use one versus the other, is when you have a small number of people that are all going to be actively involved, you can do a joint venture. When you get too many people and you want to have some of them be passive investors and other people be actively involved in, providing, we call them non-capital contributions to the company, services, providing services to the company. That's when you create this manager managed LLC, and that's the syndicate structure.
Got it. Thank you, Kim. Now, some people are out there and they're wondering probably, okay, I got it going on now. I've got my investors. What kind of rate of return should I offer my investor? Being an investor yourself, seeing the game, what would you suggest to that person to they'll do their spreadsheets, their underwriting. What do you think is the best recommendation for this person to offer their potential investors, whether it's the syndication model, the JV model, or just a rule of thumb kind of thing for investors?
So if you're, borrowing money from people, but, that can be all over the board. If you're borrowing money from hard money investors or hard money lenders, then they may be, 10 to 15% interest plus 2 to 4 points, maybe even 5 points, right? So if you're borrowing money from private investors, then you want to be less than that, right? The whole benefit of not going to the hard money lender is because my buddy over here will loan me the money cheaper. Right. So, or my aunt, or, somebody I met in my RIA will loan me the money cheaper than that. So you want to be, less than that. So maybe you can offer, 8 to 10% or something like that, and maybe you don't have to pay points. So it's whatever you can negotiate for a private loan. If you're doing a syndicate where you're actually creating an LLC that's going to sell interest to investors, you can have different types of investors. You can have what are called debt investors or equity investors. So your debt investors are really, it's just a kind of a term that we use. It's really describing people that are going to get a fixed return on their money and then could be paid off as soon as you pay back their original capital contribution plus whatever return you've offered them for the period of time that you've had their money. So this is where you would put seller financing. Or if you had some preferred equity that wanted to come in and they were going to put in, you're raising $4 million, they're going to put in $2 million, but they want to have be paid off first before your other investors. So you would create a special class for them, and then maybe you just pay them some kind of a fixed return, and then you have some agreement with them as to how that's going to work. The other type of investors are called equity investors. And so these are the people that are staying in, they want the home run, right? They're looking for the big boost in their retirement earnings. So they're going to come in and usually get a share of the profits. And you might offer them some kind of a preferred return, which really just means we're going to split profits with you in this way, but if the split that we're going to give to you doesn't equal this, fixed return that we've set, then we're going to give up some of the management share to get you there. All right. And so that's kind of the equity. So a very typical split right now for an equity investment would be 8% preferred return, a 70-30 split. But there's a step in between. So you don't necessarily go 8% to investors and then you take 30% of whatever's left. We want you to actually split cash with people 70-30, but give up some of your share if the early years don't give them their 8%, with the right to recapture that later. That's called a Class B catch-up. There's an article on our website called Class B Catch-Ups Explained. I highly recommend everybody read that wants to put these group investments together. It's very important to understand that concept. So a typical return, but so that's just part of it, right? So you're going to give them this preferred return during the period of time you own the property, but then there's going to be some equity that you're going to realize when you sell. And then that equity is going to get shared with your investors. Maybe you do your 70-30 split. So 70% gets spread back amongst the investors and divided up amongst the years that you've owned the property, added to what you've already given them. So you gave them 8 before, and now you're giving them some equity at the end, which has another, say another 8% per year is what that averages out to. So 8 plus 8, they've gotten a 16% return. That would be a very good return right now. So people are looking with these equity splits, they're really looking for returns in the 15 to 20% range.
This was incredible, Kim. You are so jam-packed with data and information. Guys, go on our website. Anything else you wanted to share? Anything you're promoting, an event coming up? Go ahead and let the audience know best way to get a hold of you or anything you're promoting.
Best thing you can do is read the book, How to Legally Raise Private Money. It's the book behind me. You can get a free digital copy of that at our website at syndicationattorneys.com. There's a tab there that says get the book. That's a digital copy you can read on your computer. If you want the soft copy you see here or the Kindle version, you can get that off Amazon. We actually have a holiday sale right now. So the prices are reduced for now, but they're going to go back up. So this is a great time to get the book.
Kim, you're amazing. Thank you so much for being on our show. We'll probably have you back again because you've got so much value to offer. Guys, follow her wherever she is on social media. Go on our website, buy her book. Kim, you're amazing. Thank you so much again for being on our show.
Thank you. And just one last thing is to check out our podcast. It's called Raise Private Money Legally.
All righty. Well, have a great day. Kim, thank you so much.
Thank you, Joe.
Wow. I hope you enjoyed that as much as I did. I hope you learned as much as I did or more. So guys, look at the comment thread. If you've seen something, heard something, want to learn more about something, please put it on the comment link below. If you're not a subscriber yet, go ahead and hit the subscribe button. Go ahead and smash that bell to hear the latest and greatest on the show. Follow me on Facebook, follow me on Instagram. I'm putting this channel together to hopefully add incredible value to you. And if you want to learn more about investing, you're new to investing, I highly recommend this book, Flex With A Plex. Also, this book, if you're having some challenges, as you can see, everybody on the show had some kind of adversity, including yours truly. So I shared a lot of that on Make It a Comeback, giving you some incredible tips to make a comeback. So get either one, Flex With A Plex or Make It a Comeback. If you want to get more tips, go ahead and go to joemendoza.com. Again, subscribe, share, like, make a comment below. I really, really appreciate you. Want to add incredible value and wish you all the best in your success in real estate and in life. Take care.
Our company is not responsible for the success or failure of your business decisions relating to any information presented by our company or our company programs, products, and/or services.